How do property offenses fit into criminal law? Understanding these offenses is crucial for comprehending legal boundaries. Let's explore the components of property offenses, distinctions in dishonesty, and the nuances of robbery and burglary. Theft under the Theft Act of 1968 defines theft as dishonestly appropriating property with intent to permanently deprive. Appropriation doesn't require all rights of ownership to be assumed. Property includes money and all tangible or intangible items. It must belong to another person with possession or control. Cases like R.V. Morris and R.V. Velumil illustrate these principles. Actus Reus involves appropriation, property, and belonging to another. Appropriation requires assuming any right of an owner. Property encompasses money, real or personal, and intangible items. It must belong to someone else with possession or control. Cases like R.V. Turner and Oxford v. Moss highlight these aspects. Mens rea includes dishonesty and intent to permanently deprive. Dishonesty lacks a statutory definition, but has exceptions under the Theft Act. Belief in a right to deprive negates dishonesty. Intention to permanently deprive covers treating property as one's own. Cases like R.V. Holden and R.V. Lavender provide insights. Dishonesty under the Theft Act includes exceptions for belief in legal rights. Section 2 of the Theft Act states, willingness to pay does not negate dishonesty. The jury decides on dishonesty. The Gauche test applies for situations outside Section 2. Case R.V. Feely exemplifies this. Common law dishonesty applies where the Theft Act does not. The Gauche test determines dishonesty in these cases. It involves a two-stage test assessing ordinary standards of reasonable people. The defendant's belief is also considered. The case of R.V. Gauche is pivotal here. Robbery involves theft with force or threat of force. Under Section 8 of the Theft Act, force must be used to steal. It is a form of aggravated theft. The maximum sentence for robbery is life imprisonment. Cases like R.V. Robinson and Corcoran v. Anderton highlight these elements. Actus reus of robbery requires theft, force, or threat of force. The timing of force is crucial. It must occur immediately before or during theft. The jury decides on the level of force. Cases like R.V. Hale and R.V. Lockley illustrate these principles. Force in robbery is a jury's decision. No specific guidance is given on the level of force. Force need not be directly applied to a person. Minimal force can suffice for robbery. Cases like R.V. Dawson and James and R.V. Clouden are relevant. Mens rea in robbery involves intent to steal with force. The defendant must have theft's mens rea, including dishonesty and intent to permanently deprive. Force must be used to facilitate theft. Gratuitous violence not intended for theft is outside robbery. Robust approaches may apply in courts. Burglary under Section 9 of the Theft Act involves entering a building as a trespasser. Two offenses exist: burglary under Section 9(1)(a) and 9(1)(b). Intent at entry is key for Section 9(1)(a). Section 9(1)(b) allows intent formation later. Cases like R.V. Collins and R.V. Walkington provide examples. Actus reus of burglary involves entry, building, and trespassing. Initial cases required substantial entry. Later cases suggest less stringent requirements. Inhabited vehicles and vessels are included under Section 9(4). Cases like B and S v. Lethley and Norfolk Constabulary v. Seekings and Gould are notable. Trespassing in burglary covers exceeding permission. Entering part of a building may suffice. The defendant must know or be reckless about trespassing. Cases like R.V. Collins and R.V. Jones and Smith are relevant. Mens rea requires awareness or recklessness of trespassing. Aggravated burglary involves possessing a weapon during burglary. Section 10 of the Theft Act covers this offense. The timing of possession depends on the type of burglary. Cases like R.V. O'Leary and R.V. Stones illustrate these points. Intent to use the weapon is not required. The Fraud Act of 2006 repealed several deception offenses. It introduced a general offense of fraud. Fraud can be committed by false representation, failing to disclose information, or abusing position. The defendant's conduct must be dishonest with intent to gain or cause loss. The maximum sentence is 10 years imprisonment. Fraud by false representation involves dishonestly making a false statement. The defendant must intend to gain or cause loss. The representation can be express or implied. No actual gain or loss is necessary. The case law highlights these elements. Fraud by failing to disclose occurs when there is a legal duty to disclose information. The defendant must be dishonest in failing to disclose. Intent to gain or cause loss is required. No actual gain or loss is necessary. This form of fraud is significant in legal contexts. Fraud by abuse of position involves dishonestly abusing a position of trust. The defendant must intend to gain or cause loss. No actual gain or loss is necessary. The position must be one where there is an expectation of safeguarding financial interests. This type of fraud is crucial in fiduciary relationships. Key cases in fraud illustrate the application of the Fraud Act. They highlight how courts interpret false representation, failure to disclose, and abuse of position. These cases provide guidance on legal standards. They demonstrate the importance of intent and dishonesty. Understanding these cases is vital for legal professionals. Robbery and burglary have distinct elements under the Theft Act. Robbery requires theft with force or threat of force. Burglary involves entering as a trespasser with intent to commit an offense. Both offenses have severe penalties. Understanding their differences is crucial in criminal law. Property offenses, including theft, robbery, and burglary, have unique components. Understanding Actus, Reus, and mens rea is crucial for each offense. The Fraud Act introduces modern perspectives on dishonesty. Recognizing these distinctions aids in comprehending criminal law's complexities. This knowledge is essential for legal practitioners.